Hey everyone, today I'll be discussing the case of Vaca vs Ca GR number 131714 decided last November 16, 1998. Now this case is about the violation of Batas Pabansa Bilang 22. Now the factual antecedents of the case are as follows. Accused in this case is Eduardo R. Vaca, who was charged for violation of BP Bilang 22, otherwise known as the Bouncing Checks Law. On March 10, 1988, Vaca issued a check for $10,000 to the General Agency for Reconnaissance, Detection and Security Incorporation, Guards for Brevity, in partial payment of the security services rendered by Guards to Irvin. The check was drawn on the China Banking Corporation. When deposited in the Philippine Commercial International Bank or PCI Bank branch at Shaw Boulevard, Mandaluyong, the check was dishonored for insufficiency of funds. On March 29, 1988, Guards wrote Irvin a letter in which it demanded payment in cash of the amount of the check within 7 days from notice. The letter was received by Irvin on the same day, but petitioners did not pay within the time given. On April 13, 1988, petitioners issued a check for 19,860 pesos and 16 centavos to Guards. The check was drawn on the Associated Bank. The voucher accompanying it stated that the check was to replace the dishonored check, the 9,860 and 16 centavos balance being partial payment for Irvin's outstanding account. The check and the voucher were received by a Guards messenger, Nolancy Pena, on April 15, 1988, but Guards did not return the dishonored check. On April 14, 1988, Guards Operation Manager Jovito C. Cabusara filed a criminal complaint against petitioners for violation of BP Bilang 22. After preliminary investigation, an information was filed in the Regional Trial Court of Quezon City, Branch 97. The case reached the Supreme Court on the ground that Vaca invoked the ruling in Lao v. Court of Appeals, in which Supreme Court reversed conviction for violation of BP Bilang 22 upon a showing that the accused had no knowledge of the insufficiency of funds. Now the issue of the case, whether or not Vaca has violated BP Bilang 22. The ruling is yes. The elements of the offense penalized under BP Bilang 22 are as follows. Number 1. Making, drawing, and issuance of any check to apply to account or for value. Number 2. Knowledge of the maker, drawer, or issuer that at the time of issue he does not have sufficient funds in or credit with the drawing bank for the payment of the check in full upon its presentment. Number 3. Subsequent dishonor of the check by the drawing bank for insufficiency of funds or credit, or dishonor of the check for the same reason had not the drawer, without any valid cause, ordered the bank to stop payment. Citing the case of People v. Lagi, the Supreme Court underscored that the maker's knowledge is presumed from the dishonor of the check for insufficiency of funds. Vaca in this case cannot pretend ignorance of the insufficiency of funds. While it may be true that it was the company's accountant who actually prepared the rubber check, the fact remains that the petitioners are the owners and officers of the company. Section 1 of BP Bilang 22 provides that where the check is drawn by a corporation, company, or entity, the person or persons who actually signed the check in behalf of such drawer shall be liable under this act. In fact, Petitioner Nieto testified that after check in question was dishonored, he instructed their company accountant to prepare a replacement check. Thus, Vaca violated BP Bilang 22.